of the estate planning and probate group here at the firm. I was to be joined today by another member of our group, McKenna Hofford, but unfortunately she's not able to participate today. But I would like to thank her for all her work in preparing for this webinar and also for her work on the PowerPoint slides that we'll be sharing with you. The topic today is a fiduciary, and it's kind of fiduciary. What is a fiduciary? And the fiduciary, in the case of estate planning, is that person that you're asking to assist you in various types of estate planning. So there are individuals that can serve as fiduciaries, and there are also professional fiduciaries, those who do it for a fee. Today we'll be focusing just on individuals that you might consider to hold a fiduciary role in one or more aspects of your estate planning. So you see here on the left, we have the fiduciary roles and types of fiduciaries: personal representative for a will, for a probate of an estate; trustee of various types of trusts; attorney in fact or agent. Sometimes those are used interchangeably, just to distinguish, for example, an attorney in fact for financial matters versus an agent maybe for healthcare matters. But both of them are really attorneys in fact. Sometimes it just maybe makes it easier for some people to think about one title in each setting, just to kind of keep them separate. And then also we have, if you have any minor children, a guardian for the minor children if you were to pass away, or if you were to become incapacitated, or possibly a trustee for a children's trust that would occur usually upon a death of the parent, because in the state of Washington, minors are not to receive or should not receive directly any kind of inheritance. You might go into a trust. There's the Uniform Transfer to Minors Act, which allows for a custodian to be appointed to hold funds. So let's start with the personal representative. Personal representative is kind of a broad term because it applies whether there is a will or there is not a will. If you get into the specific references, for example, in a will you might hear about an executor. When there's no will, typically the person is an administrator, but they really have the same function. Now, when you have a will, you can nominate your personal representative. If you do not have a will, then Washington law at least provides a list of the people in order of priority who are entitled to serve as the personal representative or the administrator. They still have to be appointed by the court in order to have any authority to do so, to act. But unfortunately, you as the person whose estate is being administered, in that situation, you have no control over who you may want to have. So some of the things that you might consider, as you see, work well with people, specifically your heirs. It is important that the person, they don't necessarily have to get along with everybody, but they need to be able to work with everybody. That could also include creditors dealing with financial matters. One consideration that people have, particularly when they have adult children, is having one of their adult children serve as the personal representative. And I think it all depends upon family dynamics. If all the children get along great, should be no problem. But if there's even one that may potentially either already be an issue for their interactions with their siblings, that can kind of put some extra pressure on the personal representative, the child who's appointed as the personal representative, because they bear the brunt of the anger of the heir or beneficiary, who may think that they either did not get what they were supposed to get, or what they thought they were supposed to get or were entitled to get, although they weren't really entitled to get anything, or they may just think that they didn't get enough of the assets of their parent. So one option then is, instead of potentially putting an adult child in in the crosshairs, so to speak, is to name maybe another family member, such as the will maker's sibling, an aunt or uncle of the children who are involved, because there may not be as much fireworks when you've got an aunt or uncle, for example, or other family member who may be able to work well with the adult children. One of the things to look at is, are they located near you? This may or may not be important. It really depends upon the nature of the estate. One of the obligations of the personal representative is to eventually do an inventory of the assets. And it's not like it's a highly detailed inventory, but if there are a lot of items of tangible personal property, it could be. And so they will have to travel to the residence, whether that be the home that was owned by the deceased individual or an apartment or condominium, whatever it might be, and they'll need to do an inventory. Depending upon the nature of the estate, there may be a number of things that they have to handle personally. It is certainly not impossible to have your personal representative be someone who lives either outside the county in which the deceased lived, or even outside the state. Never run into anything where we have a personal representative who lives outside the United States, but we have had several situations where the personal representative lived in the Midwest and traveled to Washington a couple of times in order to do the work that was needed. And so that's another consideration. Could they travel? Would they be willing to travel? This is not something where the personal representative has to have any particular knowledge on anything. No special skills required, because they can get advisors, they can get accountants, they can get attorneys, financial advisors, for example, if they need to. And the thing is, does the personal representative have the time and the interest in managing your estate? Again, depending upon the nature of the estate, this could be a relatively short-term process. A very simple estate could be probably done in less than a year. But if it's a complex estate, it may require more devotion of time. And are they willing to do that? If initially they are willing to do that and then discover after a while that they just can no longer do it for whatever reason, that is not really a problem, because they can resign and then a successor could be appointed. But one of the other things to really think about there for the personal representatives, are they willing to serve in the capacity as a personal representative? They would have to be appointed by a court, but typically, at least our experience over the last several years, is the personal representative does not need to make any kind of an appearance in court, even to be appointed. So if they're concerned about that, that should put them at ease that most likely they will not have to be in a courtroom for anything. The next area we see is with trustees. And this, as it says, is for managing the funds that are not gifted to your heirs outright. But this could also be trusts where you may have third parties that will benefit, that would not qualify as your heir, but you could still establish a trust, maybe even a charitable trust, potentially, where the beneficiary is a charity. But you may want to have an individual serving as the trustee. So here the focus really is on the financial. This is the accounting of the income and the expenses of the trust, making investment decisions if that can be done. If heirs are involved, will they keep in touch with the heirs? Because again, depending upon the nature of the trust, there may be a significant reason to stay in touch with the heirs. For example, the trust may provide that the trust assets are to be used for the maintenance, education, support, and health needs of the beneficiary or beneficiaries. The beneficiaries may not, on their own, just automatically think, oh, I need to go talk with the trust, or I need to talk with the trustee about getting some funds because I have this issue. But the trustee may have to kind of take the responsibility of contacting the beneficiaries just to see how they're doing and if they do need that. On the other hand, if there's less of a need for those funds to go for the maintenance, education, etc., there may be less of a need to be in regular contact with the heirs, because there may be something that says nothing gets distributed until the trust ends. And that may be 5, 10, or more years down the road. And so maybe the only information that the trustee might need is what's the current address for the heir, so that when the time comes to make this distribution, I know where it needs to go, or at least I know how to contact them and some good contact information. If you're considering an individual as the trustee, remember they will have some fiduciary responsibilities to the beneficiaries of the trust, but you also want to make sure that they've got some values and standards that are, if not identical to your own, very similar, so that you do feel comfortable with them. And as you'll see from all of our slides today, there is one kind of overarching principle, and that is, do you trust them? And that's true for any of these fiduciaries that you may have. Then we turn to the attorney in fact. Typically, this is for financial, but it can also be for healthcare matters. Focus here on the financial. This is someone who would assist you, usually when you are unable to, in handling any of your financial affairs. And this does not mean that they have to have a great deal of financial ability, but financial ability would certainly be helpful. If you know that they have the ability to select some advisors that are good, that can provide you a little bit more comfort as well. The financial attorney, in fact, does not need to be an accountant, does not need to be a professional financial advisor. Could be, but doesn't need to be in order to perform the function. One of the things also that we see is attorneys, in fact, can be, at least with a durable power of attorney, the attorney, in fact, can either be appointed and that appointment be effective immediately, or it can be effective only when the principal, the person who is granting the attorney, in fact, those powers, when they become incapacitated. One of the concerns that I have had expressed to me by people is, well, if I make them my attorney, in fact, immediately, does that mean that they get to make decisions for me immediately, even though I can do that? The answer is yes, they could, because their power is effective immediately. Now, if there are conflicting instructions from the principal and the attorney, in fact, and the attorney or the principal still has the necessary capacity, the person that is dealing with them should be listening to the instructions from the principal and not taking direction from the attorney, in fact. But if the principal has become incapacitated, then the third party that they are dealing with should be listening to the attorney, in fact. So as for the financial, does that attorney, in fact, know at least somewhat of your lifestyle and your assets? They don't necessarily need to know the details of them when they're appointed, and they very well may not. Often you've got a family member with a married couple, for example. The spouse is the attorney, in fact, for the other spouse. Sometimes that's not true, just because of the circumstances of the spouses. One of the spouses may not be able to serve as the attorney, in fact, or may not be willing to serve as the attorney, in fact, for the other spouse. Maybe concerned about the responsibility that they have in taking on that role. Also, in the financial, they need to be able to be at your side in an emergency and be able, maybe only in a figurative sense, not a literal sense, but at least they are available to assist you in dealing with the financial issues. And again, you want to have someone who probably has similar values and would respect your wishes and what you want done. One of the things in a power of attorney for financial matters is you can grant the attorney, in fact, the authority to make gifts on your behalf, with maybe some certain limitations. Often there is also a requirement that the attorney, in fact, consider your pattern of giving in the past, whether it be maybe the past 2 years or maybe your pattern over the last 20 years of your life, when they consider whether they should or could make a gift, as well as considering what your financial ability is, and for dealing with any future issues such as healthcare matters. If they know that there are some significant health issues coming up or that have arisen and may require some significant funding, gifting is probably not a great idea. Again, this is one of those issues of, do you trust a person? Again, the financial ability is one thing that could be important. And one of the things that I have also heard, and I think I may have mentioned, was that if you selected someone, but you're concerned about the fact that you want to make this immediate, but you're concerned about them making those decisions and having those decisions followed, even though you may still have capacity, but you're concerned, you may be thinking of the wrong person to serve as your attorney in fact, because there's a question of, do you actually trust them? Do you fully trust them? So now I'll move to agent. Again, we've talked about this one here in this case for healthcare matters. Again, they may be termed an attorney in fact for healthcare matters. These are people that you want to have in your corner making decisions if you're not able to. And it doesn't necessarily have to be the same person that you might think of for financial matters. You may have someone who is great for financial matters and you think would be terrible for healthcare matters. But on the other hand, you've got someone who would be great with healthcare matters, but you're a little concerned about them and their financial ability. I had a client at one time who was ill. He was in business. His brother was in business. He said, I want my brother on my financial, as my financial attorney, in fact, because he knows what's going on. But my client also said, no, I'm prepared to have, as he said, have the plug pulled when that time comes. But my brother won't do it. So I don't want him as my healthcare attorney. In fact, I want somebody else. Now, if you choose separate people, one for healthcare attorney in fact matters and one for the financial attorney in fact matters, you need to understand that they will on occasion have to work together. Because, for example, the healthcare agent or healthcare attorney in fact would have the authority. For example, if you were in the hospital, but then you had to go to a rehab facility before you could go home, they can choose the healthcare, the rehab facility, make all the arrangements. But typically, the healthcare attorney, in fact, does not have the power to pay for that out of the principal's funds, whereas the financial attorney, in fact, does. And so they need to be able to work together. And so one of the things you might think about, and probably should think about, is if you're going to have two different people serving in those capacities, can they work with each other? And if they can't, or you believe that they can't, maybe you should change one of those two choices. So with the healthcare, again, would they honor your wishes, even if they disagree with what your wishes are? That could be, it can put them in a difficult position if they disagree with it, but their obligation as an attorney, in fact, is to you as the principal. And so they should honor your wishes. Respect your privacy. Just because you have the information about healthcare does not mean, as the attorney, in fact, you get to pass it along. That right to the privacy belongs to the principal, and you as the attorney, in fact, are being provided with confidential information. So there's an obligation there to keep that quiet. Final one here has the capacity to assist you with doctor visits. That may or may not be the case that they attend doctor visits. You may have an attorney, in fact, whether the appointment is effective immediately or only upon incapacity, they may not attend a doctor visit, particularly if you are If you still have the necessary mental capacity, you may just attend it yourself. There's no requirement that the attorney in fact for healthcare attend those visits. Now, if you are incapacitated, it would be a very good idea that the healthcare attorney in fact does attend those doctor visits. And again, in choosing your healthcare attorney in fact, if that's going to be a consideration, how many doctor visits might you be expecting? If you're going with your current health situation, maybe there's an annual visit to the doctor, but there's nothing else. But if there is some kind of an ongoing health issue, there may be visits to a primary doctor, there may be visits to one or more specialists, and along with tests. Does the healthcare attorney, in fact, have the ability to assist you with those, and potentially all of them, regardless of how many there really might be? And then we'll move to the guardian for minor children. And this one can happen also where if you become incapacitated, you may feel the need to appoint a guardian for your minor children because you're unable to care for them. But just the fact that you are wanting to appoint someone as the guardian may not make that appointment effective, because there may be someone else who has the authority to act on behalf of the children. For example, if you're married, the other spouse probably has that right. And even an ex-spouse could potentially have a right to act on behalf of the minor children. There are some issues there, I think, with family law that I can't get into because I don't deal in family law. But there may be some issues where the ex-spouse has some rights still, even after a divorce, where they have the right to act on behalf of minor children. So you could nominate a guardian for the minor children. But again, what are you thinking about when you're nominating them? Do they know the children? Are they good with children? Have they had their own children? I think it would be difficult if you've got a minor child and you're asking someone to serve as their guardian, if they haven't had the experience of raising children. Again, it's on a case-by-case basis, but they may not be the best choice, although they may fill every other qualification you might have for them. So that's one of those things that you'll need to consider. Physically located within a reasonable area, maybe you don't want the children to be moved away from where they are. Maybe it's a question of being in the family home or a home that they're familiar with. Maybe it's a question of not wanting them to have to move schools. So in considering guardian for your minor children, that the location of the guardian may be very, very important. And it's still probably going to be very important too to maintain contact with the rest of the family, even though they're now living with the guardian in the guardian's home. But maintaining the contact with the rest of the family, whether that be extended family or other members of the immediate family for whatever reason, that will be very important because it helps with the child's raising. Again, trust can be an extremely important issue. Then we'll move into the trustee for the Children's Trust. As I mentioned earlier, in the state of Washington and probably many other states, distributions to minors cannot be made directly to the minor. But there are various options. There could be uniform transfer to Minors Act account if it's some sort of financial asset, and a custodian is appointed. But you could have a trust to hold the children's assets, and then you have a great deal of flexibility in creating the trust as to, for example, how long the trust lasts, what it's to be used for. Typically, there would not be the healthcare issues related in a trust as there would be for a guardianship, for example. So a lot of the considerations that you would have for who may be good to serve as a trustee would be similar for a trust, as we discussed earlier, and the qualifications for a financial attorney, in fact, because you're really looking at the ability to deal with the assets that are in the trust, which may or may not include money. They may include other property, and it could be even real estate. And so, do they have some experience with maintaining, whether it's maintaining a residence, making sure utilities are taken care of, and insurance and maintenance and upkeep, or maybe it's some commercial property where they may not have as much, there may not be as much need for them to be directly involved, for example, in the management. There could be a management company involved that actually operates the commercial property. But it's still going to be a financial focus for the trustee. The Children's Trust, again, depending upon the nature of distributions to be made from the trust, the trustee may be keeping in contact with the children for quite some time. It could be even if the child, maybe the trust provides that the child doesn't receive everything from the trust until maybe they get some portions of principal, maybe in one lump sum or maybe a series of lump sums separated by a few years. Then the trustee is probably going to be keeping in touch with them. Again, if the trust is then set up otherwise for maintenance, education, support, and health, there's more likely to be more regular contact between the trustee, or should be more regular contact between the trustee and the children. And since they're minors, the guardian for the children, if there's a formal guardian appointed. It is not unusual to see a children's trust set up by one spouse where the other spouse is still alive and the children are with that other spouse, but for whatever reason, the first spouse to die has set up that what they intend for the children is to go into a trust for the children's benefit, and the other spouse may or may not be the trustee of that trust. And there could be a number of reasons for that. But in any event, the trustee is still going to have to work with and communicate with the person who is responsible for the raising of the children until that point comes. So hopefully that has given you a little bit of a flavor for what kinds of things to consider when you're considering who you'd like to appoint as a fiduciary. And in summary, I guess in every one of those, you could have a different person just because of the different skill sets that they have, the different relationship they may have with family members. So as you can imagine, there are a number of things, several of which I haven't even touched on today, that would go into a consideration of who would be best for you to nominate. In some cases, like personal representative, you can nominate them, you don't appoint them. But with a trustee, you could nominate and appoint. And with the attorney, in fact, you can appoint them. So there's a number of things to keep in mind, some of which you may not think about, some of which you might. So if you have any questions, please give us a call, either McKenna or me, or Linda Nash in our office as well. And I'll we'll finish there. I hope you'll join us next week for the webinar we present next week. That'll be by our Family Law and Assisted Reproductive Technology group at 12:15 next Thursday. Thank you very much. Have a great day.